As you know, the judge also said it was confusing. The State Board of Elections argued the decision to invalidate the question this late in the process erodes confidence in the election system.
There are two different claims in this suit. So the claim relating to the improper charter material, that this charter amendment is improper charter material, it's the State Board's position that that lawsuit should have happened under 12202, if it happened under 12202, soon after the passing of the resolution by the mayor and city council, back in May of 2024.
Now, while the State Board of Elections arguments focused on the procedures of the ballot question challenge, the city's legal team has a different focus. They argue the circuit court's decision denied Baltimore City voters their right to be heard. Lawyers pushed back on the claim the ballot amendment's question was too confusing.
This is not impermissibly unclear. This language is accurate, it is precise, it tells a average Baltimorean would know exactly what this language is saying because they know the Inner Harbor, they know the streets around it, they know the landmarks in it.
Now, Thiru Vignarajah argued in defense of the circuit court's decision. He claims the language was not as clear-cut as the city argued.
There's no question that a reasonably diligent person, in fact, could have known and, in fact, did know. There were media reports. It was published. There's no question that the resolution passed in March was a matter of public record. In contrast to the language, there's no question as to that. The challenge there is that in order for us, the appellees, to be able to bring a challenge, they would have had to do it under the declaratory judgment action. It's unclear whether or not a resolution is subject to a declaratory judgment action. Under the law of the declaratory judgment action, it lists a number of things, acts, ordinances, etc., but not a resolution.
However, Maryland Supreme Court seemed to take issue with that part of the argument. The Supreme Court did not issue a decision today. We, of course, are monitoring their ruling and will bring it to you when that happens. Ashley.